Welcome back to the deep dive. We are diving deep today into a fundamental aspect of contract law, moving beyond how contracts are formed. That essential foundation of offer, acceptance, consideration, certainty, and intention we've talked about before.
hmm
Today, we're really zeroing in on what the contract actually requires. What are the parties truly obliged to do? What are the terms of the agreement?
And that shift is absolutely critical, isn't it? You
Yes.
simply cannot assess whether a contract has been breached or what the legal consequences of that breach might be until you have a really firm grasp on its content.
Right.
The terms are the very substance of the agreement. They define the boundaries of performance.
And this deep dive is made possible by materials generously made available for educational purposes. We're basing our discussion today pretty heavily on materials generously made available by the University of London. They're designed to help you unpack and understand these crucial concepts.
Think of this as a focused session purely for educational purposes, intended to clarify some really key areas in understanding contract content.
And this deep dive is brought to you by Sinorbit Academy, Sri Lanka. And look, to all of you preparing for exams right now, seriously, good luck. We sincerely hope this deep dive helps to solidify your understanding and maybe gives you a bit more confidence in tackling these important areas.
Absolutely. Because knowing how to identify and classify terms is foundational. It's not just academic theory. It's really about decoding the real-world commitments within any agreement you might come across.
Okay, so based on the material available to us, we've sort of identified three main areas we'll explore today to really get under the skin of contract content. First, we need to tackle the messy reality of contract negotiations and figure out how to distinguish between statements that become binding terms of the contract and those that remain, just mere representations.
Right, because so much gets said, doesn't it? In any negotiation, not all of it is meant to be a legal promise, a binding commitment. Second, we'll look at how terms can become part of a contract even if they weren't explicitly agreed upon, what we call implied terms. These are terms added by the courts or sometimes by statute.
And finally, the really practical part, especially for understanding remedies, how are terms classified? Are they major undertakings, minor ones, or sort of something in between? And why that classification is the absolute key that unlocks which remedies are available if the term is breached.
It all builds on that core idea, doesn't it? First, you define the obligation, you figure out what the terms are, then you can determine the consequences of failing to meet it.
Okay, let's unpack this first crucial area then. Distinguishing statements made during negotiations. Is something said or written in a term of the contract? Or is it just a mere representation? This feels like the very first filter you have to apply when you're looking at any agreement.
It really is. Imagine a typical contract negotiation. People are talking about the subject matter, its history, its capabilities, delivery times, future expectations, costs, potential profits. It's rarely a simple, I offer this, you accept.
No, definitely not.
It's a dialogue, isn't it? Full of statements intended to describe the thing being sold, or maybe just to persuade the other party. The real challenge is sorting through all that to find the specific statements that the parties, objectively speaking, intended to be binding promises within the contract itself.
And getting that classification right is just vital because the consequences, the remedies available if that statement turns out to be untrue or unfulfilled, are fundamentally different depending on which category it falls into.
Exactly right. If a statement is classified as a term, it's a promise within the contract. If it's broken, that's a breach of contract, plain and simple. The injured party is entitled to damages for that breach.
Right.
And, as we'll get into a bit later, depending on the type of term, breach condition, warranty, or innominate term, they might also have the right to terminate the contract entirely.
But if it's a mere representation, it's different. It's a statement made to perhaps induce the other party into the contract, but it doesn't become part of the contract itself.
Precisely. So if it's untrue, it's a misrepresentation. There's no claim for breach of contract because, it wasn't a term of the contract in the first place. The remedies for misrepresentation are found under a completely different area of law, which, you'll explore in depth elsewhere in Chapter 9 of the materials.
This distinction, it used to be even starker in English law, didn't it? There's some interesting history here that helps explain why classification was so hard-fought in older cases.
Oh, definitely. Before significant statutory changes like the Misrepresentation Act 1967, and also before the development of the tort of negligent misstatement following the Hedley Byrne & Co. Ltd. v. Heller and Partners Ltd. case back in the 60s, Getting damages for misrepresentation was notoriously difficult.
You often had to prove fraud, right, which is a really high bar.
Exactly. Proving fraud is very hard. So you see parties in those older cases really twisting themselves in knots, trying desperately to argue that a statement that maybe sounds like a description or an assurance was actually intended as a term of the contract.
Or maybe part of a separate related collateral contract?
Yes, that too. Their motivation was often simply to be able to claim damages, because it was just far easier to get damages for breach of contract than it was for misrepresentation in those days. You see Lord Denning commenting on the ingenuity of these arguments in cases like Esso Petroleum Co., Ltd v. Marden.
But now the situation's changed.
Well, yes. Now, the remedies for misrepresentation are much more robust. They offer various types of damages depending on the circumstances, whether it was an innocent, negligent, or fraudulent misrepresentation.
So it might even be better sometimes to claim misrepresentation now?
In many situations today, it might actually be more advantageous for an injured party to claim misrepresentation rather than breach of contract. Perhaps because of the different ways damages are calculated, or maybe the availability of the remedy of rescission.
And we need to be careful with terminology here. Rescission isn't the same as termination for breach.
Absolutely crucial distinction. Rescission aims to undo the contract from the very beginning, put the parties back where they were before the contract. Termination for breach ends the contract from the point of breach onwards. Very different concepts.
So what this historical context really highlights is that even with these improved misrepresentation remedies, correctly classifying that initial statement term or representation is still the absolutely vital first step.
It really is, and the material emphasizes this as crucial examination advice. If you're analyzing a problem question and you misclassify a statement, say, you treat a misrepresentation as a breach of term, or the other way around, you will inevitably go down the wrong legal path.
You'll discuss the wrong set of remedies.
And unfortunately, you'll lose marks no matter how brilliantly you discuss the law in that incorrect area. It's just fundamental.
Think of it as the essential signpost at the start of your legal analysis. Get the signpost right, you're on the path to the correct rules for remedies. Get it wrong, and, well, the rest of your analysis is fundamentally flawed, isn't it?
Couldn't agree more. So the big question is, how do courts actually determine whether a statement made during negotiations was intended to be a binding term or just a mere representation?
Okay, so the courts don't try to peer into the subjective minds of the parties, do they? They apply an objective test.
That's right. It's all about objectivity. What did the words and conduct of the parties suggest to a reasonable person standing in their shoes? Was the statement objectively intended to be a binding promise, creating a contractual obligation? Or was it merely an inducement, something said, to encourage the other party to enter the contract?
Applying that objective test in the messy context of real negotiations can be challenging, though.
It definitely can be. So over time, courts have developed several factors, or you could call them rules of thumb, that help indicate the party's likely objective intention.
These aren't strict legal rules, though, are they? Like a checklist?
No, not at all. There are strict rules where if you tick a box, it's automatically a term. There are indicators, pointers, that the court weighs up in the context of all the evidence. It's a balancing act.
Okay, let's look at some of these key factors. First one seems to be special knowledge. Who knew more?
Yes, who had greater knowledge or expertise about the subject matter of the statement. If the person making the statement was in a better position to know the truth than the person receiving it, it strongly leans towards being intended as a term.
The classic comparison here is Dick Bentley Productions v. Harold Smith Motors Ltd. versus Oscar Chess Ltd. v. Williams, right?
Exactly. It's a textbook contrast. In Dick Bentley, you had a car dealer selling a car. The dealer stated it had only done 20,000 miles since a replacement engine and gearbox were fitted. Now, the dealer, as a professional in the motor trade, had expertise. They had the means to check the car's history. The buyer relied on this statement.
And the court said?
The court held the statement about mileage was a term. Why? Because the dealer, with their special knowledge, was effectively warranting its truth. They were in a position to know, the buyer wasn't.
Now compare that to Oscar Chess. Different situation.
Very different. Here, a private individual was selling a car. They stated it was a 1948 model, based purely on what was written in the car's logbook. Turns out, the logbook was wrong. It was an older model.
And the buyer?
Crucially, the buyer in Oscar Chess was also involved in the motor trade. They arguably had the expertise and means to verify the age themselves, perhaps more easily than the private seller. The seller wasn't a professional dealer making a claim based on expertise. They were simply passing on information from a document they reasonably believed to be correct.
So in Oscar Chess, it was a representation.
Correct. The court held it was a mere representation, not a term. The seller didn't possess superior knowledge relative to the buyer. They were relying on the logbook, and the buyer, being in the trade, could have checked. So Dick Bentley versus Oscar Chess. That pair of cases beautifully encapsulates how the relative expertise, the special knowledge of the parties, really influences whether a statement is seen as a binding promise or just a description. Remember those names: Dick Bentley, Oscar Chess.
Okay, another factor, acceptance of responsibility. Did the person making the statement seem to be taking responsibility for its accuracy?
Yes. Did they seem to say, "You can rely on this, I stand by it"? Or maybe even discourage the other party from checking it themselves. The case of Shaw v. Reed is a good example here.
That was the horse case.
That's the one. A seller of a horse was asked about its soundness. The buyer was actually examining the horse's leg when the seller interrupted and said something like, "You need not look at the horse's leg. If he was not sound, I would not say anything about it."
Ah, so telling them not to check.
Exactly. This was seen by the court as the seller actively taking responsibility for the horse's soundness and discouraging further independent checks. That led the court to hold the statement about soundness was a term. Shaw v. Reed.
Then there's the importance attached to the statement. How crucial was it?
Yes, how important was the statement to the party receiving it, especially in their decision to enter the contract? Was it a deal breaker? Look at Bannerman v. White.
Hops and sulfur, wasn't it?
Precisely. A buyer of hops specifically asked the seller if they had been treated with sulfur. And crucially, he added that if they had been, he wouldn't even bother asking the price. He made it absolutely clear it was fundamental.
So the seller's assurance that they hadn't used sulfur
Was held to be a term. Why? Because of the clear, explicit importance the buyer attached to it. It was a fundamental condition for him entering the deal at all. Bannerman v. White.
Conversely, if the statement maker suggests verification.
Yes, the verification recommendation factor. If the person making the statement says something like, "This seems to be the case, but you really should get it checked out yourself," that leans towards it being a representation. They're signaling they aren't guaranteeing its truth. They're putting the onus back on the buyer.
Like the boat case, EKV Godfrey.
Exactly. When selling a boat, the seller made some statements about its condition, but also advised the buyer to have it surveyed. That advice suggested the statements about condition were intended merely as representations, encouraging the buyer to rely on their own expert survey, not solely on the seller's assurance. A KV Godfrey.
And finally, reliance. Did the other party clearly rely on the statement?
Yes, strong reliance is a very potent indicator leaning towards a term. Did the person receiving the statement clearly rely on it when deciding whether to contract and on what terms? We mentioned Esso Petroleum Co. Ltd. v. Martin earlier in the context of damages.
The petrol station forecast.
That's it. An experienced oil company, Esso, gave a prospective tenant a forecast of the potential throughput, the likely sales, of a new petrol station. The tenant heavily relied on this expert forecast when deciding whether to take on the lease. It was crucial to his assessment of profitability.
And the court found it was a term.
Yes, the court held that forecast was not just some hopeful prediction or opinion. Given Esso's expertise and the tenant's clear reliance, it was held to be a binding term or warranty. Esso Petroleum v. Martin, again, a very useful case.
So it's never just one factor in isolation. You have to look at everything.
Absolutely not. As Lord Moulton famously reminded everyone in Heilbut Simons & Co. v. Buckleton, these factors, special knowledge, responsibility, importance, verification, reliance, variance, they are not exhaustive or decisive tests on their own. They're helpful guides. The court must look at the totality of the evidence.
The whole picture.
The whole picture. All the circumstances surrounding the negotiation, what was said, who said it, their relative positions, the context to deduce the objective intention of the parties. Did a reasonable person, observing everything, conclude that this particular statement was intended to be a binding promise? That's the core question, guided by those factors, as confirmed in Heilbut Simons & Co. v. Buckleton.
Okay, this becomes particularly interesting when the contract is eventually put down in writing, because then we have this general principle called the Pearl Evidence Rule.
Yes, the Pearl Evidence Rule. The basic principle, established in cases like Jacobs v. Batavia and General Plantations Trust Ltd., is that where a contract has been put wholly into writing, the written document is presumed to contain all the terms of the agreement.
So you can't bring in outside evidence.
Generally, no. Extrinsic evidence is evidence outside the written document, like previous oral statements made during negotiations, That's the parole evidence bit. Or earlier drafts generally cannot be used to add to, vary, or contradict the terms contained within the four corners of that final written document.
What's the thinking behind that rule? Certainty.
Exactly. The main purpose is to promote certainty and finality in written contracts, as noted in AIB Group Playalek v. Martin. Parties should know that if it's important enough to be a term, it should be in the written agreement. The deal is what the document says it is. It prevents disputes based on hazy memories or conflicting accounts of what was supposedly agreed beforehand.
But, like many legal rules, it's not absolute. There are exceptions.
Oh yes, quite a few important exceptions where extrinsic evidence is allowed. For instance, you can bring in outside evidence to show that the written document was clearly not intended to be the entire agreement between the parties. Maybe it was just a part of it. That was seen in Allen v. Pink.
Or to prove terms that should be implied into the agreement.
Yes. Crucially, the rule doesn't prevent evidence being led to establish terms implied by custom, trade usage, or by law, which we'll be discussing in detail shortly.
You can also use parole evidence to show the contract itself is flawed.
Right, to show that the contract is legally defective from the start, for example, if it's void or voidable because of misrepresentation, mistake, fraud, or maybe lack of capacity, like non-est factum. These things undermine the validity of the written document itself.
Any other major exceptions?
You can use it to show the contract was conditional, that it hadn't actually started yet because some condition precedent hadn't been met, or maybe that it has since stopped operating. And, as we touched on briefly earlier, parole evidence is admissible to prove the existence and the terms of a separate, distinct collateral contract.
Yes, the collateral contract idea again. This is where a statement made before the main contract doesn't become a term of that main contract,
But instead forms the basis of a separate, smaller contract that exists alongside the main one. It's a way around the parole evidence rule sometimes.
And the consideration for the separate contract is usually entering the main one.
Typically, yes. The consideration given by the party receiving the pre-contractual promise is their act of entering into the main contract in reliance on that promise. Think back to our imaginary bookshop example. A statement about the shop's turnover made during negotiations might not make it into the final written sale agreement for the shop itself.
But if it was clearly intended as a promise and the buyer relied on it,
It could potentially be enforced as a term of a distinct collateral contract. Courts consider this possibility in cases we've already mentioned, like Heilbutt, Simons & Co. v. Buckleton, and Esso Petroleum Co. Ltd. v. Marden. It's a concept to keep in mind.
now, to try and avoid these sorts of arguments about pre-contractual statements altogether, especially in big commercial deals, you often see specific clauses put into the contract itself.
Yes, you often see entire obligation clauses, sometimes called entire agreement clauses.
What do they do?
These are clauses inserted right into the written contract that explicitly state that this document contains the entire agreement between the parties. They usually go on to say that no pre-contractual statements, representations, negotiations, or understandings form part of the contract unless they are specifically written into it.
And courts generally uphold these.
Generally, yes. Cases like Entrepreneur Pubco v. East Crown Ltd. And more recently, Axe Sun Life Services v. Campbell Martin show that courts will typically uphold these clauses. They see them as a clear expression of the party's intention that the written contract is indeed the whole deal, reinforcing the purpose of the parole evidence rule and promoting commercial certainty. It stops parties trying to resurrect old, perhaps forgotten, pre-contract remarks later on.
That makes a lot of sense for commercial certainty, doesn't it? Okay, so we've covered express statements made during negotiations, how to figure out if there are terms or representations, why that classification matters so much for remedies, the factors courts use, the parole evidence rule and its exceptions, and this idea of collateral contracts. Now, let's move on to the second big area. Terms that weren't explicitly agreed but still become part of the contract. Let's talk about implied terms.
Yes, this is fascinating. Contracts aren't always limited just to the words the parties consciously chose and wrote down or said. Even a very detailed, carefully drafted written contract can have additional terms added to it by external forces. These primarily come from two sources: the courts, through common law decisions, or Parliament through legislation.
But why would the law imply terms? If the parties didn't agree to it, shouldn't that just be the end of the matter? Seems a bit like interfering.
Well, there are several justifications. Sometimes it's simply practical to fill in gaps the parties didn't foresee or perhaps didn't think were necessary to state explicitly because they seemed obvious. Other times, it's to make the contract workable, to give it business efficacy, as we'll see.
Okay.
It can also be to reflect standard commercial practices in a particular trade. things everyone in that business just assumes. And crucially, especially when we look at statutory implied terms, it's often about protecting parties who might be in a weaker bargaining position, particularly consumers.
But I get the feeling courts are generally quite cautious about implying terms. It feels like they're getting very close to rewriting the contract for the parties, which isn't really their job.
They absolutely are cautious. Historically, the tests for implying terms at common law were quite restrictive, focusing heavily on necessity. It had to be necessary to imply the term, not just reasonable or desirable.
Has that changed at all?
There has been some debate. For instance, Dyson LJ in Crossley v. Faithful and Gould Holdings Ltd., later endorsed by Lady Hale in Gaze v. Societe Generale, suggested that courts should perhaps consider reasonableness, fairness, and broader policy considerations more openly when deciding whether to imply a term. However, the prevailing judicial approach, especially reaffirmed recently, remains quite reserved and cautious, particularly when dealing with detailed, professionally drafted commercial agreements. The courts are generally reluctant to interfere just because implying a term might seem reasonable or fair with the benefit of hindsight. Necessity is still key. Remember, Crossley v. Faithful and Gould is reflecting that caution.
Okay, so given that general reluctance, how exactly does a term get implied by the common law? Through court decisions.
Yes, there are a few established categories or ways this happens at common law. First, terms can be implied by trade usage or custom. If there's a well-established, notorious, certain, and reasonable practice within a specific trade or market, it can be implied as a term into contracts made within that trade.
Unless the contract says otherwise.
Exactly, unless the express terms of the contract contradict the custom. It's like adding the industry's default settings or background rules that everyone familiar with that trade would just expect to apply.
Okay, what's the second way?
Second, terms can be implied because of the inherent nature of the relationship between the parties or the particular type of contract they've entered into. These are almost like standard default terms that the law attaches to certain common contractual relationships because they are seen as necessary for that type of relationship to work properly. Lord Sine, in Equitable Life Assurance Society v. Hyman, referred to these as general default rules for certain kinds of contracts.
Can you give an example?
The classic example is the landlord-tenant relationship, particularly in multi-occupancy buildings. In Liverpool City Council v. Irwin, the House of Lords had to consider a tenancy agreement for a council flat in a tower block. The written agreement was very basic. It didn't say anything about who was responsible for maintaining the common parts, the stairs, lifts, lighting, rubbish chutes, etc., which were falling into disrepair.
So the court stepped in.
Yes. The House of Lords implied a term into the tenancy agreement that the landlord, the council, had a duty to take reasonable care to keep these common parts in reasonable repair and usability. They felt such a term was necessary, given the nature of the relationship and the type of building, for the contract to function realistically for the tenants. Without it, the tenancy would be fundamentally undermined. Remember Liverpool City Council v. Irwin for landlord's duty for common parts.
And what about employment contracts? Are terms implied there too?
Yes, employment contracts are another key area where courts imply terms reflecting the nature of the relationship. Examples include an employer's implied duty not to require an employee to work in a way that is likely to seriously damage their health. Think of Johnstone v. Bloomsbury Health Authority.
Okay.
Or the implied duty of mutual trust and confidence, which means the employer shouldn't conduct their business in a corrupt or fraudulent way that could harm the employee's future employment prospects that came up in Malik v. Bank of Credit and Commerce International S.A.
Right, the BCCI case.
Yes. And, more recently, courts have found breaches of this duty where employers acted capriciously regarding discretionary bonuses, damaging trust. See Attrill v. Dresner Kleinwort Ltd.
But again, the courts are careful about how broad these implied duties are.
Absolutely. They tend to imply specific duties based on necessity or the particular context of the employment relationship, rather than imposing very broad, vague obligations. For instance, a very specific duty on an employer to alert employees to a potential trap in a pension scheme that only the employer knew about was implied in Scally v. Southern Health Board.
But not general duties.
But compare that with the rejection of a proposed broad implied duty on employers to take reasonable care for their employees' general economic well-being in Crossley v. Faithful and Gould, which we mentioned earlier. The courts are much more comfortable implying specific duties necessary for the relationship than very wide-ranging ones. The implied duty needs to be relatively defined and seen as necessary for that specific relationship to function appropriately. Remember, scally for the specific duty, Crossley for rejecting the broad one.
Okay, so that's trade usage and nature of the relationship. What's the third main category for common law implication? This sounds like the most famous one.
Yes. Thirdly, and perhaps most famously in the case law, terms implied to give effect to the party's presumed, though unexpressed, intention. This is where those two classic tests that students always learn come into play.
The business efficacy test.
That's the first one, originating in the old case of the Moorcock. A term is implied under this test if it is necessary to give the transaction the commercial or business efficacy that both parties must have intended it to have. In the Moorcock itself, a shipowner contracted to use a wharf owner's jetty on the River Thames. It was understood the ship would rest on the riverbed at low tide.
And the riverbed wasn't safe.
Exactly. The ship got damaged. The court implied a term into the contract that the wharf owner would take reasonable care to ascertain the condition of the riverbed alongside the jetty to ensure it was reasonably safe for a ship to rest on. Why? Because without that implied assurance of safety, the contract for the use of the jetty wouldn't make any commercial sense. Why would anyone pay to use a jetty if doing so risked destroying their ship due to an unsafe riverbed? The term was deemed necessary to make the contract work commercially as intended. So, the Moorcock business efficacy test implying terms necessary for the contract to make business sense.
And the other classic test, the one with a slightly strange name.
The officious bystander test, yes.
Yeah.
This comes from Sherlaw v. Southern Foundries, 1926 LTD. This test asks, is the proposed implied term something so obvious that it goes without saying? So obvious that if, at the time the parties were making their bargain, an officious bystander, some interfering busybody, were to interrupt them and suggest including that specific term, they would both instantly reply, oh, of course, that's obviously included.
That has to be that obvious.
Yes. As McKinnon L.J. famously put it in the judgment, it must be something so obvious that the parties would testily suppress him with a common, oh, of course. The term must be something that both parties would readily have agreed to without hesitation had they actually stopped to think about it during their negotiations. Sherlaw v. Southern Foundries, the officious bystander test for obvious unexpressed terms.
Now, how do courts view these tests today? Has the thinking evolved?
There was a period of potential evolution, perhaps. Lord Hoffman, in the Privy Council case, Attorney General of Belize v. Belize Telecom Ltd., suggested that maybe the implication of a term isn't a separate process with its own special tests, but is really just part of the broader exercise of construing the contract.
Meaning figuring out what the contract means.
Exactly. Understanding what the contract, read as a whole against the relevant background, would reasonably be understood to mean. He suggested the business efficacy and officious bystander tests weren't separate rules, but just helpful ways of thinking about whether the proposed term reflects what the contract, properly understood, already implicitly means or requires to achieve its overall purpose. Remember Belize Telecom for that perspective.
But my understanding is that the UK Supreme Court later stepped back from that broader view.
Yes, very importantly they did. In the landmark case of Marks & Spencer, PLAV, BNP Paribas Securities Services Trust Company, the Supreme Court, with Lord Neuberger giving the leading judgment, firmly rejected any interpretation of Belize Telecom that suggested that traditional restrictive tests for implication had been watered down or replaced by a general test of reasonableness.
So they went back to the stricter approach.
They explicitly reaffirmed that implication of a term into a contract is a process distinct from interpretation or construction of its express terms. Reasonableness alone is not enough to imply a term. The tests remain ones of strict necessity for business efficacy, the Moorcock test, or obviousness for the officious bystander test from Sherlaw, and these tests must be applied rigorously.
What were the facts in the Marks & Spencer case?
M&S was a tenant who had exercised a break clause in their lease to terminate it early. They had already paid a full quarter's rent in advance, covering a period that extended beyond the termination date. They argued there should be an implied term in the lease entitling them to a refund of the portion of rent covering the period after they'd left.
Seems reasonable on the face of it.
It might seem fair or reasonable, yes. But the Supreme Court said no implied term could be found. Why? Because while it might be reasonable, it wasn't strictly necessary for the lease contract to work, business efficacy. Nor was it so obvious that both parties would have said, oh, of course, if asked at the time they signed the lease, officious bystander. Lord Neuberger was very clear. Implying terms is about finding terms the parties must have intended to include, not just adding terms that a court later thinks would have been reasonable or fair to include. So Marks & Spencer, PLTV, BNP Paribas, is really crucial. It firmly reestablished the high bar, the restrictive approach for applying terms at common law.
And recent cases have followed that line.
Yes, cases like Boussaint-Mon v. BGC brokers reinforce that the court's focus must be on the parties' apparent intentions at the time the contract was actually made, based on what was known then, not on what seems fair or sensible to a judge looking back at the situation with the benefit of hindsight.
So despite the tests being framed in terms of intention, the courts remain particularly reluctant to imply terms into detailed, written commercial contracts that have been negotiated between sophisticated parties, often with legal advice.
That's generally true. The assumption is that such parties have considered and included everything they intended to include in the written document. We saw this reluctance mentioned in cases like Philips Electronic, Grand Public, SAV, British Sky Broadcasting Ltd., and Mediterranean Salvage and Towage Ltd v. Seamar Trading and Commerce, Inc. The Marks and Spencer decision really hammered home this restrictive approach for detailed commercial agreements.
However, there's a slightly different perspective sometimes suggested for less detailed agreements, maybe ones that are more skeletal.
Yes, there's an interesting strand of thought, perhaps most associated with Leggett J., as he then was, in the case of Yam Seng Piney Ltd v. International Trade Corp. He suggested that in less detailed, more relational contracts, implied terms, potentially including even a general duty of good faith and performance, might be more readily implied to make the contract workable and reflect the parties' likely expectations of how they would cooperate.
Okay, this leads us directly into a specific and somewhat controversial area of debate: the implied term of good faith.
Right. Now, the concept of good faith is absolutely central to many civilian legal systems, like those in continental Europe. It often imposes broad duties on parties during negotiation and performance.
Right.
But traditionally, English contract law hasn't recognized a general, overarching principle of good faith applying to all contracts.
It's been more piecemeal, specific duties in certain contexts.
Exactly. Good faith concepts have appeared in specific areas, like duties of disclosure in insurance contracts or duties on fiduciaries. Here, in the context of implied terms, we're talking more narrowly about potentially implying a duty on parties to perform their existing contractual obligations in good faith. This is perhaps less startling than implying a duty to negotiate in good faith, but it's still a significant potential development.
And this idea gained a lot more prominence recently, didn't it, with a very high-profile case?
It certainly did, particularly with the Bates v. Post Office No. 3 litigation. This was the case involving thousands of subpostmasters and massive problems with the post office's Horizon accounting software, which led to devastating consequences for many of them.
And the court found an implied duty of good faith there.
Yes. Crucially, the High Court found that the contracts between the post office and the individual subpostmasters were examples of what are increasingly being termed relational contracts. And because they were relational contracts, the court held that an obligation of good faith should be implied into them as a matter of law. Bates v. Post Office, really important for relational contracts and implied good faith.
So what exactly defines a relational contract in this context? What makes a contract relational?
Well, the judge in Bates didn't provide a strict definition, but he identified several characteristics that tend to indicate a contract is relational, making an implied duty of good faith more appropriate. These included things like there being no express term in the contract excluding a duty of good faith, the contract being long-term, the parties intending their relationship to be performed with integrity and fidelity to their bargain, the parties expecting a high degree of communication, cooperation, and predictable performance based on mutual trust and confidence, the spirit and objectives of the contract being perhaps hard to capture exhaustively in detailed written rules, one or both parties having made a significant investment based on the relationship, often some degree of exclusivity in the relationship.
So those characteristics from the Bates judgment help identify these contracts.
Yes, they provide a framework or a set of indicators for identifying contracts where a mutual expectation of good faith performance seems inherent in the relationship itself, justifying the implication of such a duty. Remember these characteristics from Bates.
But even if you imply a duty of good faith, it can't override the actual words of the contract, can it? The express terms still rule.
Absolutely critical point. An implied duty of good faith must be consistent with the express terms of the contract. It cannot be used to contradict or undermine what the parties explicitly agreed. For example, in SDI Retail Services v. Rangers FC, an argument for an implied duty of good faith was rejected, partly because it would have been inconsistent with specific express terms that gave one party considerable discretion. Consistency is key.
And just labeling a contract relational doesn't mean the parties are locked together forever or can't exercise their contractual rights.
Precisely. Identifying a contract as having relational aspects doesn't automatically prevent a party from exercising clear termination rights or enforcing specific clauses according to their terms. The New Balance v. Liverpool FC case showed this clearly.
That was the football kit deal.
Yes. While the long-term contract between the kit supplier, New Balance, and the football club, Liverpool, certainly had relational aspects, Liverpool was still held to be entitled to terminate the contract when New Balance failed to precisely match a competitor's offer from Nike under the terms of a specific matching right clause in the contract. Even though New Balance might have acted with integrity, the court focused on the objective meaning of the matching clause itself, not just the overall relational spirit. New Balance v. Liverpool FC.
It sounds like there's still perhaps some judicial disagreement or maybe just different approaches emerging regarding this whole concept of relational contracts and implied good faith.
Yes, that's a fair assessment. It's still a developing area. For example, the decision in UTB LLC v. Sheffield United, another case involving a football club context, a shareholder dispute, seemed to treat the question of implying a good faith duty not as an automatic consequence of labeling the contract relational, but more as a question of fact to be determined based on the parties' specific intentions in that particular commercial arrangement. The court found no implied duty there.
So, different approaches.
It seems so. While Bates v. Post Office was undoubtedly highly significant and brought relational contracts into the spotlight, the precise boundaries, the automaticity of implying good faith, and its application are still being worked out by the courts. It seems likely to depend heavily on the specific facts, the express terms, and the particular judicial perspective in each case. UTB v. Sheffield United shows a potentially more cautious approach.
Okay, that's a really thorough look at implied terms by common law. The other major source of implied terms you mentioned is statute, Parliament stepping in.
Yes, absolutely. Over many years, Parliament has intervened to imply certain terms, or perhaps more accurately nowadays, impose specific duties into particular types of contracts. This is often done to standardize expectations across common transactions and, very importantly, to provide protection for parties who might otherwise be vulnerable, especially consumers.
And the landscape here changed significantly quite recently, didn't it? With a major piece of legislation.
Yes, the big change came with the introduction of the Consumer Rights Act 2015, CRA 2015, which came into force in October 2015. Before the CRA, key statutes like the Sale of Goods Act 1979, SGA, and the Supply of Goods and Services Act 1982, SGSA, applied, albeit sometimes differently, to both business-to-business, B2B contracts, and business-to-consumer B2C contracts.
So what's the setup now?
Now, the CRA 2015 provides a separate comprehensive legal regime specifically designed for B2C contracts, contracts between a trader and a consumer covering goods, services, and also digital content. The older statutes, the SGA 1979 and the SGSA 1982, still primarily govern B2B contracts, although some parts might still be relevant where the CRA doesn't apply.
Okay, so let's start with B2B contracts. For the sale of goods between businesses, we look mainly to the Sale of Goods Act 1979, the SGA.
That's right. The SGA 1979 applies several fundamental terms into B2B contracts for the sale of goods, unless these terms are properly excluded. And exclusion itself is subject to further rules, particularly under UCTA 1977, which was the topic for Chapter 6.
What are the key implied terms under the SGA for B2B?
Okay, first, SGA Section 12 implies a term concerning title, basically, that the seller has the right to sell the goods. This is fundamental. The buyer needs to know they are getting good title, SGA S212. Second, SGA Section 13 implies a term that where goods are sold by description, they will correspond with that description, SGA S133.
We touched on this earlier, the strictness debate with description. Cases like Arcos versus Reardon Smith.
Exactly. Historically, cases like Arcos v. EA Ronison & Son applies very strictly. Remember the wood staves having to be exactly half an inch thick. Even a tiny deviation meant a breach, regardless of whether the goods were still usable. Later cases like Reardon Smith Line Ltd v. Hansen Tangent, about a ship's description, suggested a more nuanced approach, looking at whether the descriptive words related to a substantial ingredient of the good's identity. The potential harshness of Arcos might now be mitigated somewhat by SGA Section 15A, which says a buyer can't reject goods for a breach so slight it would be unreasonable, but S13 itself remains a potentially powerful term about description. Remember Arcos and Reardon Smith for that strictness versus substance debate.
Okay, what about the quality of the goods in a B2B sale? That seems crucial.
Absolutely. SGA Section 14, subsection 2, implies a term that the goods supplied under the contract are of satisfactory quality. This is a really important one. However, there's a key condition. This term is only implied if the seller sells the goods in the course of a business.
And what does satisfactory quality mean?
The Act itself, in sections 14.2a and 14.2e, gives guidance. It says goods are of satisfactory quality if they meet the standard that a reasonable person would regard as satisfactory, considering the description, the price, if relevant, and all other relevant circumstances. It lists specific aspects of quality to consider, including fitness for all the purposes for which goods of that kind are commonly supplied, appearance and finish, freedom from minor defects, safety, durability.
So it's quite a broad assessment.
Yes, it looks at the overall quality. The price is relevant. You'd expect higher quality from expensive goods than cheap ones. And if goods are described as, say, seconds or shop soiled, that lowers the expected standard. Remember SGA S.14 Hen 2.2 for satisfactory quality.
What if the buyer needs the goods for a specific particular purpose, not just a common one?
That's covered by SGA Section 14, subsection 3. This implies a term that the goods are reasonably fit for any particular purpose that the buyer, expressly or by implication, makes known to the seller before the contract is made. Again, this term is only implied if the seller sells the goods in the course of a business.
Can you give an example?
Sure. If you go to a specialist shop and tell them you need waterproof boots specifically for hiking across boggy moorland, and they sell you a pair recommended for that purpose, SGA S.133 implies a term that those boots will be reasonably fit for hiking across boggy moorland. If they leak on the first boggy patch, there's likely a breach. Remember SGA S.143 for fitness for a particular purpose.
You've emphasized that these Section 14 terms only apply if the seller sells in the course of a business. How broad is that? Does it just mean their usual day-to-day selling activity?
Not necessarily just their core business activity. The case of Stevenson v. Rogers clarified this point significantly. It involved a fisherman who sold his fishing boat. Now, selling boats wasn't his regular day-to-day business activity, fishing was, but the court held that this sale was still made in the course of a business.
Why?
Because the sale was a transaction connected with, or incidental to, his business as a fisherman. It wasn't a purely private sale unrelated to his business. So in the course of a business can cover transactions that are integral to or form part of the seller's wider business activities, not just their routine sales of stock and trade. Remember Stevenson v. Rogers for that broader interpretation.
Are there any limits on the satisfactory quality term? What about obvious defects?
Yes, Section 14.2c provides limits. The implied term of satisfactory quality does not extend to defects that are specifically drawn to the buyer's attention before the contract is made. Nor does it cover defects that a reasonable examination by the buyer ought to have revealed if the buyer actually examined the goods before contracting. See Bramhill v. Edwards on this point regarding pre-purchase inspections.
Okay, that covers B2B goods. What about B2B contracts for the supply of services?
For B2B services, we look primarily to the Supply of Goods and Services Act 1982, SGSA. The key implied term here is in SGSA Section 13. This implies a term that the supplier will carry out the service with reasonable care and skill. Again, this is only implied if the supplier is acting in the course of a business. This is the baseline standard of competence you expect from any professional service provider. SGSA S13, reasonable care and skill.
Okay, so that's the B2B landscape under SGA and SGSA. Now, what about B2C when a business sells goods or supplies services to an ordinary consumer?
Right. This is now primarily governed by the Consumer Rights Act 2015, CRA 2015. The CRA was specifically designed to consolidate and enhance consumer protection law.
Does it use the same language of implied terms?
Interestingly, it uses slightly different language. Instead of implying terms into the contract, the CRA imposes statutory duties on the trader regarding the goods or services supplied. However, the substance and effect of these duties are very similar to the implied terms we've just discussed under the SGA and SGSA.
And presumably, these consumer rights are harder to exclude.
Yes, that's a key feature of the CRA. The rights and duties it sets out generally cannot be excluded or restricted by the trader. This links to Chapter 6 on exclusion clauses, but it's a fundamental aspect of the CRA's protection.
So what are the main duties under the CRA 2015 for goods sold to consumers?
Okay, very similar substance to SGA. CRA Section 11, subsection 1 imposes a duty that the goods must conform to description. CRA SPOS.111. CRA Section 9, subsection 1 imposes a duty that the goods must be of satisfactory quality. The factors for assessing this, listed in S.9.27, are very similar to those under SGA S.12p. Fitness for purpose, appearance, freedom from defects, safety, durability, etc. CRA sector equality. CRA Section 10, subsection 1 imposes a duty that the goods must be reasonably fit for any particular purpose that the consumer made known to the trader, expressly or impliedly, before purchase. CRA S.101, fitness for particular purpose.
And for services supplied to consumers under the CRA.
The main duty is in CRA Section 49, subsection 1. This imposes a duty on the trader to perform the service with reasonable care and skill. Again, mirroring SGSA SCN 13, but framed as a non-excludable duty owed to the consumer. COA S49, reasonable care and skill.
It's fascinating how the law has evolved these parallel but distinct regimes for B2B and B2C contracts, aiming for similar standards but providing stronger protection against opting out for consumers.
It absolutely reflects a clear policy shift towards enhancing consumer rights and clarity.
Okay, so we've now identified statements as terms or representations, and we've seen how terms can be implied into contracts either by common law or by statute. Now we come to the final, really critical piece of the puzzle: classifying the terms. Why does it matter so much whether a term is seen as a major promise or just a minor one?
This is where everything clicks together, connecting the terms of the contract to the available remedies if those terms are breached. It's fundamentally important. As we established earlier, if a party breaches any term of the contract, fails to perform one of their primary obligations, they automatically incur a secondary obligation.
Which is to pay damages.
Exactly. They have to pay damages to the injured party to compensate for the loss caused by that breach. That's the baseline remedy for any breach of contract.
But sometimes the injured party gets something more, an additional, much more powerful remedy.
Precisely. In certain situations, they might also gain the right to terminate the contract. Termination means bringing the contractual relationship to an end from that point onwards. The injured party is then discharged from having to perform their own remaining obligations under the contract.
And they can still claim damages.
Yes, and crucially, they can claim damages not just for losses incurred up to the point of termination, but also for the loss of the entire bargain, the profit or benefit they expected to receive if the contract had been performed fully in the future. It's a very significant remedy.
So classification of the term tells you whether you get that powerful termination option.
That's exactly what it does. The classification dictates the remedial possibilities. If the term that's been breached is classified as a condition, which signifies a major essential term, or if the breach of an innominate term, we'll define that shortly, is sufficiently serious in its consequences.
Then the injured party has a choice.
Yes, they have an election. They can choose either to, A, terminate the contract, treat it as repudiated, and claim damages for all losses, past and future resulting from the loss of the bargain, or R, affirm the contract, choose to keep it alive despite the breach, and claim damages only for the specific loss caused by that particular breach.
And what if the term breached is only a warranty?
If the term breached is classified as a warranty, which signifies a minor, less essential term, then the injured party's only remedy is damages. They do not have the right to terminate the contract just because a warranty has been breached. The contract must continue.
This is so incredibly crucial for problem questions, isn't it? It's the absolute bridge between finding the term that's been broken and figuring out the potential legal outcomes for the client.
It's absolutely fundamental. You cannot advise on remedies without classifying the term first. This whole area links directly to the topics of performance and breach, Chapter 12 in the materials, and the detailed rules on assessing damages.
And just to reiterate that point about terminology, we're talking about termination for breach, ending the contract prospectively. This is different from rescission, which applies to things like misrepresentation and aims to undo the contract retrospectively as if it never existed.
Absolutely vital to keep those terms distinct. Use termination for ending a contract due to breach.
Termination sounds like a pretty drastic step. Can it be used unfairly, perhaps?
It certainly can be, or at least there's a risk of it. Imagine a situation where the market shifts and a long-term contract suddenly becomes very unprofitable for one party. They might then start searching meticulously for any tiny technical breach by the other side. If they can find a breach of a term that happens to be classified as a condition, they might try to use that minor slip-up as a legal justification to terminate the entire contract and escape a bad bargain.
Using a technicality to get out of an unwanted deal.
Exactly. And this potential for abuse is one reason why the courts have sometimes developed the law, particularly around classification, to try and prevent such opportunistic or unfair uses of the termination right.
The traditional approach, going back to the 19th century, focused primarily on just two types of terms, didn't it?
Yes, the classical model really developed the concepts of conditions and warranties, specifically to distinguish those breaches that were considered serious enough to justify ending the contract, going to the root of the contract, from those that were less serious.
So conditions were the major terms.
Yes, conditions were seen as the major essential terms of the contract. The critical point is that any breach of a condition, no matter how minor its actual consequences might be in the specific circumstances, was traditionally held to give the injured party the right to terminate the contract and claim damages.
Even if the breach caused no real loss.
Yes. You didn't necessarily have to prove the breach caused significant loss to gain the right to terminate if the term is a condition. Think about those strict cases like Bose v. Shand, where the rice for shipment had to be loaded in the contractually specified months, March, April, not February, even if it arrived at the same time, or Moore and Landauer, where tinned fruit had to be packed in cases of 24 tins, not 30, even though the buyer received the correct total number of tins. These showed the strict approach. Any failure to meet the exact requirement of a condition was potentially fatal to the contract. Bose v. Shand, Moore, and Landauer are examples of strict conditions.
And warranties were the minor terms.
Correct. Warranties were seen as the minor, subsidiary, or collateral terms promises, but not essential to the main purpose of the contract. Breach of a warranty only entitles the injured party to claim damages for whatever loss the breach actually caused. They absolutely cannot terminate the contract just because a warranty has been broken. Warranty means damages only.
And as we mentioned before, the Sale of Goods Act 1979 largely adopts this structure, doesn't it? It classifies many of its key implied terms, like those relating to title, description, quality, fitness, as conditions.
That's generally correct for the SGA, yes. It uses that condition warranty framework. Now, outside of statute, at common law, how do courts decide if a term is a condition or a warranty? Again, just like when distinguishing terms from representations, the ultimate test is the party's intention, objectively ascertained.
So, what did the parties, viewed reasonably, intend the consequences of breaching this term to be?
Exactly. Did they intend this particular term to be so important, so fundamental, that any breach of it, however small, would justify the other party in ending the entire contractual relationship?
How did courts figure out that intention? Are there clues?
Well, first, they look for express classification by the parties themselves within the contract. If the contract explicitly labels a particular term as a condition, that's obviously very strong evidence of the party's intention that it should be treated as such.
But it's not always conclusive. I seem to remember a case where the label wasn't followed.
You're right, it's strong evidence, but not always decisive. The famous case illustrating this is L. Schuler AGV Wickman Machine Tool Sales, Ltd. This involved a long-term distribution agreement where one clause required a distributor, Wickman, to make a specified minimum number of visits, 1,400 visits in total over 4.5 years, to 6 specific large UK motor manufacturers each week to solicit orders for panel presses. Clause 7b stated it was a condition of the agreement that Wickman carry out these visits.
Okay, sounds important, and they called it a condition.
Yes. Wickman, however, missed a relatively small number of these visits over the initial period. Schuler, the manufacturer, sought to terminate the entire long-term agreement, arguing that Wickman had breached a condition.
But the court disagreed.
The House of Lords ultimately held that despite the parties explicitly using the word condition in Clause 7b, it was, in legal effect, an innominate term. We'll come to those. They reasoned that interpreting it as a condition, which would allow Schuler to terminate the entire multi-year agreement for just a single missed visit out of thousands, would lead to such an unreasonable and commercially absurd result that the parties, viewed objectively, could not have genuinely intended that drastic consequence.
So the label condition wasn't enough when the consequences seemed disproportionate to the breach.
Exactly. The court looked beyond the label to the overall context and the likely commercial intention, finding that the potential consequences of treating it as a strict condition were just too severe. L. Schuler v. Wickman Machine Tool Sales is critical. It shows intention is key, but the label isn't always the final word, especially if it leads to absurdity.
However, using other specific language can be very effective in making something a condition. Like saying, time is of the essence.
Yes, absolutely. Using specific, well-understood phrases like stating that time is of the essence in relation to a performance deadline, like payment or delivery, is usually taken as a very strong, often conclusive indication that the parties intended timely performance to be a condition of the contract.
Is there a key case for that?
Lombard North Central Pohkikit v. Butterworth is a prime example. A contract for the hire purchase of a computer contained a clause stating that punctual payment of each installment was of the essence of the agreement. The hirer paid some installments late. The finance company terminated and repossessed the computer. The court upheld the termination, holding that the time of the essence clause clearly made punctual payment a condition, so any late payment, regardless of how short the delay, entitled the finance company to terminate. Remember, Lombard North Central v. Butterworth, where the effect of time is of the essence.
Okay, so that's express classification. What if the contract doesn't explicitly say if a term is a condition or warranty? How do courts infer the party's intention then?
If there's no clear express classification, the courts have to draw the proper inference from the nature of the contract as a whole, the specific term in question, and the surrounding circumstances. They ask, objectively, how important does this term seem to be to the overall purpose of the contract? Does it go to the root of the contract? This goes back to cases like Ben v. Burness.
The classic comparison often used here involves opera singers, doesn't it? Bettini v. Gay and Poussard v. Spears.
That's right, they provide a neat contrast. Both cases involved contracts with opera singers who fell ill. In Bettini v. Gay, the singer was contracted for a season of performances, but missed several days of rehearsals beforehand due to illness. He was ready for the first performance, though. The court held that the term requiring attendance at rehearsals was only a warranty.
Why?
Because while rehearsals were important, missing a few didn't fundamentally undermine the main purpose of the contract, which was for him to perform during the season. The manager could claim damages for any disruption caused by the missed rehearsals, but couldn't terminate the whole contract just for that. It didn't go to the root.
Now compare that with Poussard v. Spears.
In Poussard, the singer became ill shortly before the opening night of a new opera. She missed not only the final rehearsals, but also the crucial opening night and the first few performances. By the time she recovered, the opera company had already hired a replacement singer for the entire run because her absence at the start was so critical.
And the court said this was different.
Yes. The court held that the obligation to be ready to perform from the opening night did go to the root of the contract. Missing the start of the run was considered a breach of condition, entitling the opera company to terminate her contract and engage someone else permanently. So, Poussard v. Spears, missing opening night's condition, versus Bettini v. Gay, missing rehearsals, warranty. It shows the court assessing the relative importance of the obligation within the context of the overall contract.
This strict condition warranty distinction, while it may be clear in theory, seems like it could be quite rigid in practice. It's very black and white. Either you can terminate for any breach or you can only get damages. Couldn't that lead to harsh or unfair results sometimes?
It certainly could, and that was a growing concern. The all-or-nothing nature of the condition warranty classification didn't seem to fit the reality of many contractual obligations, where the seriousness of a breach might depend entirely on its actual consequences in the particular situation. This is why the introduction, or perhaps recognition, of a third category of term, the innominate term, sometimes called an intermediate term, in the Court of Appeal decision, Hong Kong Fur Shipping Co. Ltd v. Kawasaki Kisen Kaisha Ltd. was such a landmark development.
So, innominate terms are a sort of middle ground.
Exactly. The court in Hong Kong Fur recognized that many contractual undertakings are complex, and it's impossible to say definitively, in advance, whether any breach of that term will always justify termination, like a condition, or will never justify termination, like a warranty. The importance of the breach, and therefore the appropriate remedy, might depend entirely on the nature and consequences of the specific breach that actually occurs.
So, with an innominate term, you don't classify the term itself in isolation as major or minor. Instead, you look at the effect of the breach that has happened.
Precisely. The test for an innominate term, established in Hong Kong Fur, focuses on the consequences of the breach. It asks, did the actual breach that occurred, in the circumstances it occurred, deprive the injured party of substantially the whole benefit, which it was the intention of the parties that they should obtain from the contract?
So, if the consequences are really serious...
If the consequences of the breach are so serious that they effectively destroy the main benefit the innocent party was supposed to get from the contract, then the breach, although of an innominate term, has the effect of a breach of condition. The injured party then gets the right to terminate.
But if the consequences are less serious...
If the consequences are not that serious, if the injured party is not deprived of substantially the whole benefit, then the breach is treated like a breach of warranty. The injured party can claim damages for the loss caused, but they cannot terminate the contract. The contract continues. Remember, Hong Kong Fur innominate terms. seriousness of consequences test.
And the Hong Kong fur case itself provides the classic example of how this works, doesn't it? The ship charter.
Yes, it's the perfect illustration. The case involved a 2-year time charter party for a ship, the Hong Kong Fur. The contract included a term requiring the ship to be in every way fitted for ordinary cargo service, essentially, a seaworthiness obligation. However, the ship turned out to have significant engine problems and an incompetent engine room crew, which made it unseaworthy for quite some time at the start of the charter, causing significant delays while repairs were done and crew replaced.
So the charterers tried to terminate?
Yes, the charterers argued that the seaworthiness term was a condition and its breach entitled them to terminate the 2-year charter. The Court of Appeal disagreed. They classified the general seaworthiness obligation as an innominate term. Why? Because a breach could range from something trivial, a missing nail, to something major, the ship sinking. You couldn't say in advance that any breach would justify termination.
So they looked at the consequences of this specific breach, the delays.
Exactly. They looked at the actual consequences the delays caused by the initial unseaworthiness. While these delays were significant, about 20 weeks out of a 24-month charter, the court concluded they were not so serious as to deprive the charterers of substantially the whole benefit of the remaining very substantial period of the charter party. Therefore, the breach, though serious enough for damages, did not justify termination. The charterers only had a claim for damages for the period the ship was off hire.
This innominate term approach was later applied in other contexts too, like sale of goods contracts outside the specific SGA conditions.
Correct. A good example is Seehave NV v. Bremer Handelsgesellschaft MBH, often known as the Hansa Nord. This involved a contract for the sale of citrus pulp pellets for use in animal feed. The contract included a term requiring the shipment to be in good condition. On arrival, a portion of the pellets was found to be damaged, overheated.
But they were still usable.
Yes. Importantly, they were still perfectly usable for their intended purpose, making animal feed, although their market value was reduced. The buyers, however, tried to reject the entire shipment, arguing the good condition clause was good condition. The court disagreed. They treated the good condition clause as an innominate term.
And looked at the consequences.
Yes. Looking at the consequences of the breach, the damage wasn't so severe as to prevent the pellets from being used for their intended purpose. The court held the breach was not serious enough to justify termination of the whole cargo. The buyer's remedy was limited to damages representing the difference in value between sound pellets and the damaged ones they received. Seehave v. Bremer, Hansa Nord, applying Hong Kong fur to a quality term in sale of goods.
The innominate term approach just seems to offer much more flexibility than the rigid condition warranty distinction. It allows courts to tailor the remedy to the actual impact of the breach and prevents parties from using trivial breaches as technical excuses to get out of contracts.
It definitely does. It promotes a sense of fairness by focusing on the substance of the breach's effect rather than just the label of the term. However, its main drawback is the potential lack of certainty up front.
How so?
Well, until a breach actually occurs and its consequences are assessed, which might only happen after the event, potentially in court, the parties don't know for sure whether a breach of an innominate term will give the injured party the right to terminate or not. This uncertainty can be commercially problematic, especially in fast-moving markets, where parties need to know quickly and definitively whether they can walk away from a deal or if they're still bound.
And this is why, in certain areas, certainty is often prioritized, leading courts back towards classifying terms as conditions, particularly things like time clauses in commercial contracts.
Exactly. The need for predictable outcomes and the ability for parties to rely on strict compliance, particularly in contexts like international trade or shipping, often means that clauses specifying shipment dates, delivery times, or notices are frequently treated by the courts as conditions, even if a minor delay in a specific instance might not seem devastating in itself. Certainty trumps flexibility in these contexts.
Are there key cases showing this preference for certainty with time clauses?
Yes. Cases like Mar Delonto Campagna Naviera S.A. v. Bergbau Handel GmbH, the Los Angeles, which involved an expected readiness to load clause in a charter party being treated as a condition, and Bungie Corporation v. Tradax Export S.A., where a clause requiring a buyer to give notice of a vessel's readiness to load cargo by a specific date was held to be a condition, demonstrate this principle. They emphasize that in mercantile contracts, time stipulations are often crucial and should be treated as conditions to ensure market certainty. Remember Mar Delonto, the Los Angeles, and Bungie v. Tradax for time clauses often being conditions.
But it's not automatic for all time-related clauses.
No, it still depends on construction.
Mm.
For instance, in a more recent case, ARC Shipping Co., LLC v. Silverburn Shipping, IOM Ltd., a clause in a charter party requiring the owners to maintain the vessel's classification certificates was held by the Court of Appeal to be innominate, not a condition, showing the court still looks at the specific term and context.
It also seems the influence of the Hong Kong fur seriousness of consequences approach extended beyond just creating the innominate category. Didn't it also affect how courts interpreted terms that parties themselves had called conditions?
Yes, you could certainly argue that the reasoning in Hong Kong fur influenced the outcome in L. Schuler v. Wickman, where the House of Lords looked past the condition label because the consequences of treating every minor breach as grounds for termination seemed so commercially unreasonable.
And it might also influence how courts interpret very broad express termination clauses.
Potentially, yes. For example, in Rice, T.A. Guardian v. Great Yarmouth Borough Council, the court was reluctant to allow termination under a clause that seemed to permit termination for breach of any term, however minor. They suggested such clauses might need to be interpreted in line with the Hong Kong fur principle, implying termination is only allowed for significant breaches, even if the clause wording seems broader.
But contrasting with that flexibility, there are still situations where courts strongly uphold strict classification to maintain certainty, especially when the contract language is crystal clear about the importance of a term.
Oh, absolutely. Think back again to Lombard North Central v. Butterworth. The contract explicitly said time is of the essence for punctual payment. The court upheld that as making punctual payment a condition, meaning any delay, however brief, justified termination. No messing about with consequences there.
And there was that property case with the very short delay.
Yes. Union Eagle Ltd v. Golden Achievement Ltd. A contract for the sale of property in Hong Kong made time of the essence for completion and payment. The buyer was literally 10 minutes late in tendering the payment on the completion date. The Privy Council held that this breach of condition entitled the seller to terminate the contract and forfeit the deposit, even though the delay was minimal and caused no real prejudice. It shows the law will still uphold strict classification where the party's intention for absolute certainty, especially regarding time and property or commercial deals, is made unequivocally clear. Lombard and Union Eagle show certainty can still win.
It really does highlight that constant tension in contract law, doesn't it?
Yeah.
That balancing act between providing clear, predictable certainty for commercial planning and allowing enough flexibility for courts to achieve just and fair outcomes based on the actual reality and impact of a breach.
It's a recurring theme you see running right through contract law. And understanding these classifications, condition, warranty, innominate, and crucially, how courts arrive at them by interpreting the party's intentions and sometimes assessing the consequences of breach is absolutely non-negotiable if you want to properly analyze breach and advise on remedies.
This brings us right back to how absolutely crucial this knowledge is for putting everything together, especially for anyone facing exams or dealing with contracts in practice.
Exactly. As the University of London materials rightly point out, issues about identifying and classifying terms are unlikely to be the only thing going on in a complex problem question, but they're almost always the essential first step. If you misstep here, if you misclassify a statement or a term, the rest of your analysis of breach and remedies will likely crumble.
So, okay, let's imagine you're presented with a typical problem question scenario. Your thought process should start with identifying the potential terms, right?
Absolutely. First job, identify the obligations. What statements were made during negotiations? Were they intended to be expressed terms? Here you apply that objective test. Using those rules of thumb, we discuss special knowledge, Dick Bentley versus Oscar Chess, importance attached, Bannerman, acceptance of responsibility, Shaw, verification, Ike, reliance, Esso.
And if it's a written contract,
Then you have to consider the parole evidence rule. Does it apply? Is there an entire agreement clause? Entrepreneur, AXA. Are there any relevant exceptions to the rule, like proving the document wasn't the whole agreement, Allen v. Pink, or proving implied terms, or maybe proving a collateral contract, Hobbit Simons, Esso?
okay, once you've sorted the express terms, you look for implied ones.
Exactly. Step 2. Can any terms be implied? First, by common law. Is there relevant trade usage or custom? Does the nature of the relationship suggest an implied term? Liverpool City Council, Malik. Or is a term necessary for business efficacy? The Morgock. Or so obvious it passes the officious bystander test? Sherlaw. Remember the caution following Marks and Spencer v. BNP Paribas necessity or obviousness, not just reasonableness. And consider if it might be a relational contract where good faith might be implied, Bates v. Post Office, bearing in mind the ongoing developments. You do TBV Sheffield.
And then implied terms by statute. This seems very common in problem questions.
Very common indeed. So is this a B2B contract governed by the Sale of Goods Act 1979, SGA, or the Supply of Goods and Services Act 1982, SGSA? Or is it a B2C contract governed by the Consumer Rights Act 2015, CRA? Identify the correct statute.
Then the specific section.
Yes. Which specific sections are potentially relevant? For BB goods, SGA S.12, title S.13, description, S.1 thing 2, satisfactory quality, fitness for particular purpose. For B2B services, SGSA S.33, reasonable care and skill. For B2C goods, CRA S.9, satisfactory quality, S10 fitness for purpose, S.11, description. For B2C services, CRA S.49, reasonable care and skill. Remember to check the in the course of a business requirement for SGA's GSA, Stevenson v. Rogers. And remember, the CRA duties are generally non-excludable.
Do you also need to consider exclusion clauses at this stage?
You definitely need to spot if there are any express exclusion clauses mentioned in the facts that might try to exclude these implied terms. A full analysis of their effectiveness belongs in the topic on regulating terms, Chapter 6, UCTA CRA Part 2. But you should certainly note their presence and briefly consider if they might be relevant or likely ineffective, especially against consumer rights.
Okay, so you've identified all the relevant express and implied terms. What's the next crucial step?
Step 3. Classify the term that has allegedly been breached. Is it a condition, a warranty, or an innominate term?
How do you do that?
You look at the evidence. Did the parties expressly classify it? Remembering Schuler v. Wickman on labels. Did they use specific language like time is of the essence, Lombard, Union Eagle? Is it a term implied by statute that the statute itself classifies as a condition, like many key SGA terms? Or, if none of the above give a clear answer, is it likely an innominate term where you'll need to proceed to assess the consequences of the breach using the Hong Kong Fur test?
And only after classifying the term and, if necessary, assessing the seriousness of the breach's consequences.
Can you confidently determine the remedies available to the injured party? Is it termination plus damages for breach of condition or a serious breach of an innominate term? Or is it damages only for breach of warranty or non-serious breach of an innominate term? That's the final payoff of the analysis.
Right, let's try and quickly walk through the sample problem question provided in the material about Albin's car to see how this structure works in practice. Remind us of the basic facts.
Okay, Albin is a surveyor. He buys a 9-month-old car from Brenda's garage, which is clearly a business. He intends to use the car primarily for his surveying practice. 4 months after buying it, so the car is 13 months old, the engine gearbox seized up completely. There was an express 3-month guarantee from the garage, but that has obviously expired. Albin had also declined an offer to buy an extended warranty. The cost to repair the engine and gearbox is £2,000. We need to advise Albin. There's also a variant asking, what if you use the car mainly for shopping on Saturdays?
Okay, so the core issue seems to be the express guarantee is gone. Does Albin have any rights based on implied terms about the car's quality or fitness?
Exactly. So first step, which statutory regime applies? Is this a B2B or B2C? Albin is a surveyor using the car mainly for his practice. That points strongly towards a B2B contract. He's buying it in a business capacity.
What about the variant using it mainly for shopping?
The variant introduces the possibility of it being B2C. If his primary use was personal domestic shopping, then he might qualify as a consumer under the CRA 2015, even if he occasionally used it for work. But for the main scenario, buying it for his surveying practice makes it look like a B2B deal. We should probably consider the in the course of a business test from Stevenson v. Rogers regarding Brenda's garage selling it. But as a garage, that's clearly met. The focus is on Albin's status as buyer. Let's proceed, assuming B2B first for the main question.
Okay, if it's B2B, we look to the Sale of Goods Act 1979, SGA.
Correct. We looked at the implied terms in Section 14 as Brenda's garage sold it in the course of business. First, SGAS .14.2 implies a term that the car must be of satisfactory quality. What would a reasonable person expect of a 9-month-old car bought from a garage? Certainly not for the engine and gearbox to seize up just 4 months later. You'd consider durability under S.140B. A major failure like this strongly suggests a breach of satisfactory quality.
What about fitness for purpose?
SGA S.43, ACRI, implies a term that the car is reasonably fit for the purpose made known. Albin needed it for his surveying practice, which obviously requires driving. A car whose engine seizes is clearly not fit for the purpose of driving, so likely a breach of S.132.
Now, what about that expired 3-month guarantee, or the fact he declined an extended warranty? Do they get the garage off the hook regarding these implied terms?
This is where you need to bring in the law on exclusion clauses, primarily the Unfair Contract Terms Act, 1977, UCTA, for B2B contracts, Chapter 6 stuff. UCTA, as point 6 says, liability for breach of the implied terms in SGAS 1315 can only be excluded or restricted insofar as the exclusion clause satisfies the requirement of reasonableness.
Would limiting liability for major defects in a nearly new car to just 3 months be considered reasonable? It's highly unlikely. A court would probably find that attempting to exclude liability for fundamental defects like engine seizure in a 13-month-old car via a mere 3-month guarantee is unreasonable under UCTA. Similarly, declining an optional extended warranty doesn't negate the baseline statutory implied terms. So the implied terms under SGAS point likely still apply despite these facts.
Okay, what if it was the BDC variant used for shopping?
Yeah.
Then we use the Consumer Rights Act 2015 CRA.
Right. For the B2C variant, you'd apply the CRA. CRA S9 imposes a duty on the trader, Brenna's Garage, that the car must be of satisfactory quality. Again, engine seizure after 13 months points to a clear breach. CRA S201 imposes a duty that it's fit for the particular purpose made known, even if just general driving for shopping. Again, breached.
And can these CRA duties be excluded by the 3-month guarantee?
No. Under CRA S31, a trader cannot exclude or restrict liability for breach of the duties under sections 9, 10, or 11 description. So the expired guarantee and declined warranty are completely irrelevant to Albin's rights under the CRA if he qualifies as a consumer. So, under either SGA, B2B, or CRA, B2C, there seems to be a breach. What about the classification of these terms, duties, and the remedies?
Under both the SGA and the CRA, the terms duties relating to satisfactory quality and fitness for purpose are generally considered equivalent to conditions or statutory rights giving similar remedies. A major defect, like a complete engine and gearbox seizure, especially in a relatively new car, is undoubtedly a very serious breach.
So Albin has the right to terminate.
Yes. This serious breach gives Albin the right to terminate the contract. Under the CRA, this is explicitly called the short-term right to reject within 30 days, which is passed here, or the final right to reject after repair placement options. Under SGA, breach of condition generally gives the right to reject. He can reject the car, get his money back, and also claim damages. The damages would certainly include the £2,000 repair cost if he chose to repair it instead of rejecting, and potentially other consequential losses caused by being unable to use the car for his practice, loss of earnings, higher car costs, etc. You might briefly mention SGA, S155A, no rejection for slight breach, but engine seizure is clearly not slight.
So just to summarize the structure for an exam answer on this. 1. Identify the core issue, implied terms, re-quality fitness after express guarantee expires. 2. Determine if B2B, SGA, or B2C, CRA, discuss Albin's status, course of business. 3. Identify the relevant implied terms duties, SGA S.103 or CRA S.90. 4. Confirm they are implied, trader sold in course of business. 5. Discuss if any exclusions, guarantee, warranty apply and are effective. Mention UCTA reasonableness for B2B, non-excludability for B2C. 6. Classify the breached term duty, condition or equivalent. 7. Assess the seriousness of the breach, major fundamental. 8. Determine the available remedies, termination, rejection, plus damages.
That's a perfect structure, covers all the key steps logically.
And what about an essay question? The sample asks about the clarity, or lack thereof, of rules determining whether a breach gives the right to terminate compared to the rules for assessing damages.
Yes. That question is inviting a direct discussion of the certainty versus flexibility tension we explored, particularly concerning the classification of terms, condition versus warranty versus innominate.
You'd contrast the approaches.
Exactly. You discuss the traditional condition warranty approach, highlighting its potential certainty, but also its rigidity and potential for harshness, using cases like Bose v. Shand, Remore, or Union Eagle. Then you'd contrast that with the development of the innominate term approach following Hong Kong Fur.
Emphasizing flexibility, but uncertainty.
Precisely. Explain how Hong Kong Fur allows for more nuanced, flexible justice based on the actual consequences of the breach, using Hong Kong Fur itself and perhaps Sea Have, the Hansa Nord, as examples. But acknowledge the inherent uncertainty this creates for parties before a breach occurs and is assessed. You'd use cases that illustrate this tension, perhaps L. Schuler v. Wickman, flexibility despite label, versus Lombard North Central, certainty via time is of the essence, or Hong Kong Fur itself versus the mercantile time clause, cases like Los Angeles or Bungie.
And the question asks to compare this with the clarity of damages rules.
Yes, and you should engage with that comparison. You could argue that while classification rules have this inherent tension and uncertainty introduced by innominate terms, the principles for assessing damages, while complex in their own right, covering causation, remoteness, mitigation, etc., perhaps have a more established, albeit detailed, framework. Although, you could also point out that even damages rules are subject to interpretation and recent case law development, so perhaps the contrast isn't as stark as the question implies.
So a good essay would analyze why this lack of absolute clarity exists in term classification.
Yes, explain. It stems from the law trying to balance competing policy goals. The desire for commercially sensible and just results based on the severity of the breach, preventing opportunistic termination for trivialities, versus the equally important commercial need for predictability and certainty, so parties know exactly where they stand and can plan their affairs accordingly.
This has been an incredibly detailed and I think really clarifying look at the content of contracts. It feels like we've really unpacked the core components.
Absolutely. And understanding terms, how to identify them, how they get into the contract, whether expressly stated, implied by the courts, or implied by statute, and critically, how they are classified, condition, warranty, anominate, is truly foundational. You simply cannot analyze breach or advise on remedies effectively without mastering this first crucial step.
It's essential knowledge, isn't it, for tackling problem questions in exams, obviously, but also for understanding any real-world agreement you might encounter.
It really is that crucial shortcut for the learner. The key to cutting through the complexity of agreements, to understand the core commitments, the structure, the obligations within them.
And throughout this deep dive, we've repeatedly seen the law grappling with that fundamental tension, that balancing act between certainty and flexibility.
We have, on one hand, having clear, predictable rules for what constitutes a term and what the consequences of breaking it are, provides vital confidence for contracting parties. They need to know where they stand. But on the other hand, the law also recognizes the need for flexibility.
How so?
Well, whether that's through implying terms to make a contract workable or reflect unstated assumptions, or through the development of the innominate term approach to allow remedies to be tailored to the actual seriousness and impact of a breach. It's about achieving just and fair outcomes based on the specific circumstances, not just rigid rules.
Which leaves us, and you, the listener, with that thought-provoking question to consider further, drawing from the source material. How do you think the law should strike that balance? Should the primary emphasis always be on achieving absolute certainty in contract terms and remedies, perhaps even if that sometimes leads to results that seem harsh or overly technical in individual cases?
Or is it more important for the law to retain significant flexibility, allowing courts the room to imply terms based on necessity or fairness, or to assess the impact of a breach through the innominate term doctrine, even if that inevitably means less predictability for the parties before a dispute arises?
Where should the balance lie? Certainty versus flexibility. It's a fundamental tension, isn't it? Woven deep into the very fabric of contract law.
Definitely something worth mulling over as you continue your studies and think about how contract law operates in the real world.
Well, that's all for this deep dive into the crucial topic of contract terms. We sincerely hope this has been valuable in helping you understand these key concepts and how they fit together.
Yes, good luck with your ongoing studies and especially with any upcoming exams.
And we'll catch you on the next deep dive.